is now back in session. The next case is Robert Allan Teffeteller versus Richard Duggar, and a companion case, Robert Allan Teffeteller versus the state of Florida. Ms. Backus, you may proceed. Now, counsel, remember, on the time when the yellow light comes on, you ring the rebuttal.
Thank you, Your Honor. May it please the Court. My name is Terry Backus. I'm representing the interests of Mr. Robert Teffeteller today. The issue before the Court today was relinquished upon request by the state prior to the Court's consideration of the lower court's summary denial of Mr. Teffeteller's Rule 3.850 post-conviction motion. I state that fact to remind the Court that the case has bounced back so many times on collateral matters that are ancillary to the Rule 3.850 motion, that I wanted to make sure that we're all aware that the 3.850 motion is still pending before the Court and it has never been addressed by this Court.
Wait a minute, it's still pending in here?
Yes, Your Honor.
But it was ruled on, the last motion that we sent back was ruled on rightly or wrongly by the circuit.
Yes, it was summarily denied by the lower court.
Let me ask you, if I may, and maybe help us cut to the chase a little bit. There was a Pearl hearing,
Yes.
and then the judge asked for memorandum to dealing with the other issues in the case.
Yes.
Did the state file a memorandum?
The state filed a memorandum in response to a memorandum that had been filed pro se by Mr. Teffeteller.
Okay, but did counsel for Mr. Teffeteller ever file a memorandum?
Counsel for Mr. Teffeteller did not file a memorandum. He had filed a motion for extension of time. And keep in mind the circumstances under which this happened. Mr. Kissinger, who was Mr. Teffeteller's counsel at the time, had been appointed to represent John Earl Bush at the time. He had apprised the court of that fact at the end of the court.
I recognize that is a problem, but nonetheless, the judge denied his request for an extension, and
Yes.
so counsel for Mr. Teffeteller just ignored the filing of a memorandum, and none was ever filed. Is that correct?
No, he did not ignore the filing of the memorandum. He had filed, prior to the time that the memorandum was due to be filed, notice of appeal on the issue of the Howard Pearl case. At that time, and what's reflected in the court's ruling, is that at that point the court lost jurisdiction over the matter, and that's reflected in the order denying Mr. Teffeteller's pro se motion.
Okay,
but I agree it was a procedural mess at the time.
But nonetheless, now there's been a final ruling by the judge on the 3.850 as well as the Howard Pearl, and and you say that everything was done or not done in regard to the judge ruling on that motion.
Yes, if I could clarify, the summary denial of the original Rule 3.850 motion had already taken place, and jurisdiction was within this court. The matter that was before Judge Foxman at the time was the issue of the Howard Pearl conflict of interest claim. He limited it to that issue. Even though counsel had argued that he was entitled to a hearing on other matters, Judge Foxman stated several times in the record that he recognized that he had lost jurisdiction over some of those issues at that time. However, he did ask for argument on those factors. Mr. Kissinger did argue those factors at the end of the evidentiary hearing, to the extent that he said that Mr. Teffeteller was not waiving any of those claims specifically, that he had a fear that the 30-day time limit assigned by the court would interfere with the warrant case that he was assigned to. And keep in mind, in the warrant case that was assigned, that case had never been a CCR case. In other words, Mr. Kissinger had to learn that case from the ground up, and the execution date was set very near the time that the memorandum was due.
Isn't the state correct, though, that the Pearl issue has now been resolved, and it's up for us for review? We have to review the resolution of the Pearl issue. But otherwise, it's now time for this court to review the order of the court earlier entered, which summarily denied relief. And
That's correct.
Really to do that, that's been really pending. We didn't direct any new hearing on any of those issues in our previous remand. And generally what we were doing there was saying, look, trying to separate out all those, the Pearl issue from all the other, proved to be unworkable in this particular case. So we sent the Pearl issue back, to be treated really like another 3850 issue, if you will.
Correct.
That's now been done. We have earlier briefing, do we not?
Yes,
on
you
the
do.
previous order. So that's all there and available for us to review, is it
Yes.
not? And isn't that what our obligation is now?
Certainly, and that was my point in bringing that to the court's attention, that both of these factors are before the court, and I didn't want the court to lose sight of the fact that it was only the conflict of interest claim that was before the court. All of the claims are now before the court.
And it's your position that there needs to be no evidentiary hearing on the 3.850 issues raised in regard to counsel, the competency of counsel?
No, to the contrary. It's my position that Mr. Teffeteller was entitled to an evidentiary hearing on the ineffective assistance of counsel claims that he raised in his original Rule 3.850 motion.
But that's the position you took in the previous briefing, right?
That's correct.
The briefing
That's
that
correct.
is, you all have argued both sides of the court's earlier summary denial of the motion, right? And we have those briefs still here in the court.
Yes, Your Honor. The briefs are still with the court. I don't believe an oral argument had been held on that issue, which is why we're here today. Before we get to the conflict of interest issue, I wanted to bring to the court's attention these other matters in the original Rule 3.850 motion. Mr. Teffeteller raised significant and compelling reasons why he was entitled to an evidentiary hearing on his original Rule 3.850 motion. There was some discussion, and if you'll look at the transcripts of some of the hearings that were held regarding the Rule 3.850 motion, there was a difference of opinion regarding whether the state and the judge had actually conceded a hearing, and it's very confusing to read the transcripts because it appears that the court and the state at one point concede that a hearing is necessary on the ineffective assistance of counsel claims. Later on, it's not quite so clear, and by the end, when the court finally summarily denies the motion, he does so on some procedural bar grounds and finds some portions of the 3.850 meritless. It's Mr. Teffeteller's position that he was entitled to a hearing on those claims, that the claims that he raised were not a part of the record and could not have been conclusively rebutted by the record, which is required under Lemon.
And I think this is part of the problem that troubles me. It seemed that the judge recognized that these issues were out there, and he asked for assistance from counsel for Teffeteller to file a memorandum to address those issues.
Yes.
He did not do so. Teffeteller on his own probably did a very good job in his motion for rehearing, as good as could be done. But what is the responsibility of a judge in that situation?
Well, I think in this situation, he was limited by the fact that the issues in the original Rule 3.850 were resting with this court, and he didn't have the ability to go back and revisit those issues, even though indications were that he wanted to do that.
You mean our prior order did not send back to him the resolution of the 3.850 ineffective assistance of counsel?
Certainly it was open to interpretation. However, he stated at the very beginning that he was under the impression that his mandate from this court was to specifically deal with the conflict of interest claim that was raised in the Heritage case and also raised in Mr. Teffeteller and a number of other cases.
But why did he ask for memorandum in dealing with the other issues?
Well, I think there was some question in his mind as to whether he should deal with those issues or exactly what to do with that. Mr. Kissinger did attempt to argue the position that he was entitled to an evidentiary hearing on those claims, but at that point, the jurisdiction over those issues was with this court, and he had lost jurisdiction over those issues. And if I might point out, Mr. Teffeteller did, pro se, file a memorandum on his own, which was ordered to be responded to by the court. The state did respond to that memorandum. However,
Are you going to pick out a couple of those issues today and attempt to demonstrate that there must be an evidentiary hearing?
Well, they're all tied together with the conflict of interest claim. It's very hard to distinguish between the two when you come to ineffective assistance of counsel. And I'll deal with blanketly the ineffective assistance of counsel claims that were raised in the original 3.850 motion, particularly the issues at guilt phase and then at the subsequent resentencing. The issues that were raised in the original Rule 3.850 motion regarding the guilt phase concerned several areas directly relating to conflict of interest, which was before the time that Mr. Teffeteller was aware that Mr. Pearl was a special deputy sheriff. He had alleged conflict of interest on several grounds. First of all, there had evidently been some type of reward or monetary reward offered by the Volusia County Bar Association. The significance of that was that Judge Foxman was a member of the Volusia County Bar, as was Mr. Pearl at the time. And those issues were ones that Mr. Teffeteller was asking Mr. Pearl to explore for the possibility of a conflict of interest. As well, there were other areas in which Mr. Pearl was alleging a conflict of interest with regard to Mr. Pearl's representation of Mr. Teffeteller's interests in regard to challenging the law enforcement officers from Texas and Mr. Pearl's refusal to do so because, in his words, he wanted to save the taxpayers some money. And I think you can look at the record itself and see where the deficiencies are and read them in conjunction with some of the issues that were raised in the appellant's brief. Particularly in the guilt phase, at the beginning, Mr. Pearl reserved opening statement at the beginning of trial saying that he was going to reserve that for his portion of the case. He either forgot to do it or did not do it, and at that time presented no evidence whatsoever during the guilt phase. That issue in and of itself has to be proven with extra record material, and those types of testimony and that type of evidence can only be adduced at an evidentiary hearing. Under Lemon, he's entitled to an evidentiary hearing on those issues. As well, and was particularly troubling to Judge Foxman, were resentencing issues regarding ineffective assistance of counsel, which he was represented at resentencing by Mr. Corrente. And Mr. Corrente's failure to investigate a wealth of mitigation evidence that was not presented. And it's obvious from the transcripts that Judge Foxman was troubled by that and went through quite an inquiry as to what those possibilities were.
Before you sit down, could you tell us, we have a habeas petition pending too, is that correct?
Yes.
What's the main thrust of your habeas?
Well, during the direct appeal of Mr. Teffeteller's case, Mr. Chris Quarles was his appellate counsel. Mr. Quarles had attempted to conflict off the case because he felt that there were issues regarding Mr. Pearl's representation that needed to be raised, which he could not do because he was also a member of the same public defender's office. He requested that he be given leave to withdraw. He was not given that opportunity. There were issues regarding his ability to represent Mr. Pearl as far as in an appellate capacity, Mr. Teffeteller, in an appellate capacity, which pretty much handcuffed him from being able to raise some of the issues that he thought were necessary but should have been raised more properly in a Rule 3.850, but he felt compelled to raise some of these issues in the direct appeal brief, and that's a substance of the issues. There are some other issues in the habeas, but that's some of the main issues.
How could the conflict issue be raised in the appellate brief if there's nothing, the record wouldn't demonstrate that? I agree that that's the 3. Isn't that a 3.850 now?
Certainly it is, and I think...
How does it What's the habeas got to do with that?
Well, I think Mr. Quarles wanted to reach some issues regarding Mr. Pearl's failure to object to, in particular, some extradition issues and some issues regarding the challenging of the Texas law enforcement activities and certain prior activities. And he wanted to address that in the appellate brief because he thought it affected the way he was able to raise those claims in the direct appeal. I understand that. I understand that.
Okay.
However, he did make the motion to withdraw based on that. I see that I'm into my rebuttal time. I'll reserve my time.
May it please the court, I'm Ken Nunley, and I represent the state of Florida in this appeal. As Justice Anstead stated in questioning to my opponent, the whole package of this case is before this court now for final disposition.
But in that regard, did we not in 1996 deny the 3.850 relief that was pending and send it back for a hearing and indicate that Mr. Teffeteller was entitled to an evidentiary hearing on those claims in which the ineffective assistance of counsel were not conclusively rebutted by the record? Did we do that?
In all candor, Your Honor, the decision of this court is very, very difficult to understand, to ascertain exactly what this court said to do with regard to Mr. Teffeteller. The state's position is, and I believe it's supported by the opinion, that the Teffeteller case, and of course there were a bunch of defendants at issue here. Teffeteller went back for a Howard Pearl hearing. This court held on to the habeas appeal, or rather the habeas petition that was before it, and did not decide the 3.850 non-Howard Pearl claims. The non-Howard Pearl claims, as I understand it, have been argued before this court. The briefs are before this court. The circuit court had no jurisdiction. And in fact, my opponent has now conceded that the circuit court had no jurisdiction. So quite honestly, I'm very curious as to why there are complaints raised that Mr. Kissinger was involved in a death warrant in another case. I mean, apparently there was no basis for them to file anything anyway, at least based upon their position they've taken this morning. As to the specific...
The opinion of this court that you're referring to as sending this back is the opinion that was rehearing denied July 1996. It's 676 Southern 2nd 369.
Yes, sir, that's it.
Okay.
And
what you're saying is that if there is no specific direction in this opinion as to what happens to other than the Howard Pearl issues.
Unless it's
yes, sir. The opinion, well, let me back up. That's not the way I want to say that. The non-Howard Pearl claims were summarily denied after a Huff hearing by the circuit court back in, I believe it was 1990. It's been a substantial period of time. We didn't call it a Huff hearing.
That was Judge Driver did that, okay.
Well, and subsequently, Judge Foxman did that in the Teffeteller case. It was before Huff was actually decided, so it wasn't called a Huff hearing, but there was a hearing conducted in March, I believe, of 1989, where the parties went through each and every claim contained in the 3.850 motion and argued whether or not there should be an evidentiary hearing conducted on each and every one of the 29 claims contained within the 3.850 motion that was then pending before Judge Foxman. All but 3 of those claims were denied on procedural bar grounds. The only claims that were not denied on procedural bar grounds were a guilt phase ineffective assistance of counsel claim, a penalty phase ineffective assistance of counsel claim that doesn't have anything to do with Howard Pearl. It's a different attorney. and an ineffective assistance of mental state expert, which challenged the evaluation conducted by Dr. Harry Kropp. Those issues were briefed to this court in the case number 77-646, but it's the first brief that was filed in 77-646 that was written by former Assistant Attorney General Barbara Davis. Those three claims, which are the only claims that are at issue properly as to whether or not summary denial was proper, the failure to recuse Judge Foxman was raised on appeal from resentencing and was rejected by this court. The rewards to state witnesses was insufficiently pled. The claim concerning Teffeteller's arrest in Georgia is absolutely unintelligible and wholly meritless if you attempt to decipher what it says. The extradition suppression issue was found meritless by this court on direct appeal. The prosecutorial misconduct claim was insufficiently pled because no instances of prosecutorial misconduct were even identified in the pleading.
So is it your position that what we should do is go back and look at all those briefs on that subject and decide whether or not they were properly denied as a matter of law?
Yes, sir, it is. This case was properly summarily denied as to the non-Howard Pearl claims.
But we've never really ruled on that, have we? As to whether or not it was properly denied.
Again, Your Honor, it's a little bit unclear as to whether the court has actually ruled on it or not. I don't believe, reading the opinion, the court has decided that issue.
Let me ask, we indicated in that opinion that we vacate the trial court's order denying the appellant's Rule 3.850 relief and remand for new proceedings. What does that mean? Or is that unclear?
The opinion remanded for Howard Pearl proceedings. Judge Foxman asked the parties.
But let me continue. Moreover, as to those claims which raise ineffective assistance of trial counsel that are not conclusively rebutted by the record and which demonstrate a deficiency in performance that prejudice the defendant, the appellants are entitled to an evidentiary hearing. And I guess my question is, did Judge Foxman point out those issues raised and show in the record where they had been rebutted and entitled to a summary ruling?
Let me make sure I understand your question, Your Honor. You're asking, did Judge Foxman summarily deny again? Did he redo the summary denial?
Did he follow the instruction of the court in this opinion?
Yes, sir, I believe he did. The opinion did not vacate claims that are rebutted by the record or that are conclusively rebutted by the record. And that is what Judge Foxman's original finding in the 1989, or the original 3.850 proceeding was, that the claims were rebutted by the record and there was no need for an evidentiary hearing. Now, whether or not Judge Foxman and the state bandied back and forth at the Huff hearing, whether or not we need to have an evidentiary hearing on these claims doesn't matter. Judge Foxman ultimately determined that he did not need an evidentiary hearing on the non-Howard Pearl claims because they were conclusively rebutted by the record.
Does he say that?
Yes, sir, he said that in 1989 in the order generated from the March 89 Huff hearing.
We vacated that order.
Sir?
We vacated that order and sent this back. And I think that's what's troubling me. We sent it back for a new hearing and for a new consideration. And we get a summary denial of those. And do we know upon what basis he ruled?
The basis of the summary denial as to the non-Howard Pearl issues
Right.
has not changed. Judge Foxman, and I'm a little bit fuzzy on exactly what you're asking me about.
Well, let me give this a whirl, Mr. Nunley. if you look at do you have the opinion in front of you? That 676 opinion?
I'd have to dig for it, Your Honor.
Okay.
I think I'm familiar enough with it.
It says specifically, moreover, as to those claims which raise ineffective assistance of counsel and are not conclusively rebutted by the record and which demonstrate a deficiency in performance that prejudice the defendant, the appellants are entitled to an evidentiary hearing. Now, when this case went back, did the trial court give the appellant an evidentiary hearing on that issue in your view? Was it were you reading that? Was the state reading that to be the Howard Pearl issue that was being talked about?
No, sir, I'm not. That refers to, I guess, the other issues.
The other
the non-Howard Pearl issues.
Okay.
Judge Foxman probably should have entered an order, and again, I'm not conceding that this is what he should have done, but perhaps he should have entered an order saying, I meant what I said when I denied the non-Howard Pearl issues before. I'm re-entering that same order. Maybe he should have done that. I think implicitly in the court's ruling, that is what he did. Once you get past the issue that Justice Harding brought up of what is the court supposed to do when he orders a response and the defendant just doesn't respond and files notice of appeal and unquestionably divested the court of jurisdiction at that point in time. Excuse me. And again, there is no need to send the case back again for another order passing on in allowing Judge Foxman to say, well, okay, I should have entered this order in 96 saying that I am still standing on my 1989 or 90 order, because it's implicit in what he said, what he did. He knew what the court said. He obviously concluded that he did not need an evidentiary hearing on claims that are conclusively rebutted by the record, as his prior order had found. And, you know, procedurally, the case is incredibly confusing. It has a bunch of different ways that it goes, and it's difficult to get a handle on, quite honestly. I think I'm the third or fourth lawyer to have this case for the Attorney General's office, and it's, you know, I'm well aware of how difficult and how confusing this matter is. But the bottom line is Judge Foxman did what he was supposed to do the first time he had the case, when he denied summarily the 3.850 motion.
Well, but why would we, if that's the case, why would we send it back?
I don't think that's what we did.
And vacate that order? Other than the fact that we might have been wrong. But
you weren't going to let me say that, were you, sir?
But the truth of the matter is, we vacated that order, did we not? And sent it back for a new consideration of those non-Pearl issues. And we get back a summary denial of the orders again in light of our instructions, and it's difficult for us to understand. We don't know why he ruled. The first time we didn't know why he ruled. That's the reason we sent it back. Now we don't know why he ruled again.
As to the non-Howard Pearl issue.
As to the non-Howard Pearl issue.
But again, Your Honor, the defendant had his chance and did not take it.
That's an interesting point. What is the judge supposed to do if the defendant's attorney does not file a memorandum as requested? Deny him relief or consider the issues and rule on them as best the judge can without a memorandum?
I guess he's in the same position that, well, not that anybody would ever do it, but I guess he would be in the same position as this court would be if one party were to just simply decline to file a brief. I think he's got to decide the best he can based on what he's got in front of him.
Well, that's not quite the same analogy.
It's not a good analogy.
That you raise the issues and point them out. Here you have a separate pleading whose sufficiency has to be determined, and that is the 3850 petition. The memorandums are just sort of a gloss on that. That is a further argument or refinement kind of thing. So that's
difficulty
with that.
That's not a good analogy. It's a lot different. It's a different thing, but I think he's got to do the best he can. I mean, I don't think, but the bottom line is, once the notice of appeal was filed, he couldn't do anything at all. He lost jurisdiction of the case at that point in time. He couldn't do anything. As to the habeas,
let me ask,
I'm sorry.
Didn't Teffeteller pro se file a motion for rehearing of that order denying summary relief, pointing out that he was entitled to evidentiary hearing on certain issues?
Mr. Teffeteller filed something pro se. I don't have a clear recollection of what it was, but I don't doubt that that's what it said.
And that was before the notice of appeal was filed?
Yes, sir. That was before the notice of appeal was filed.
And so that issue could have been dealt with at that point, whether it was appropriate for Mr. Teffeteller to bring it up or not.
And there you get into the point of, or the issue of whether it's one lawyer, one brief, or one pleading, and whether a pro se defendant can file something in addition to what his lawyer files and all that. But putting all that aside, the state filed a memorandum of law addressing the issue, and according to what Ms. Backus said, it was in response to Teffeteller's pro se pleading, so I guess the issue was briefed out, or memorandumed out, perhaps, before the court. And if you want to going down that road, accepting Teffeteller's pro se pleading as sufficient, then the court decided he didn't need an evidentiary hearing on the summarily denied claims. The summary denial is proper, and that's what's before this court. As to the habeas that's before the court, it really deserves little comment. It's been fully answered by the state in our prior pleadings. Whether or not Mr. Chris Quarles wanted to raise issues that went to Howard Pearl's guilt phase performance is beside the point, and as Justice Grimes pointed out, legally he couldn't raise those claims in that posture. There's no ineffective assistance on the part of appellate counsel and again, the state has fully answered all of the claims contained in the habeas petition. The law was changed as to some of them. The victim impact claim specifically, there's one claim that there's some Booth evidence presented. Of course, Booth, as everybody knows, is no longer the law.
I'm listening to both of y'all, and it seems to me you're both saying this. Now, you tell me if I'm wrong as far as the state's concerned. That we have before us now that we ought, of course, we got to review the propriety of the ruling on the Howard Pearl issue. And we also need to go back and look at the briefs that were filed before and rule as to whether or not any of them warranted an evidentiary issue. Is that right?
Yes, that's correct. The whole package is up here.
I'll ask other counsel and see if she agrees.
And I think in response to that, what is that language in our opinion vacating that issue and sending it back and asking for an evidentiary hearing on those issues? And when we get another summary denial of those issues, aren't we in the same place we were back in 1996? We don't know any more now than we do then, than we did then.
Well, the order's the same. as the order is the same now as it was when Judge Foxman entered it. And I don't remember the date of the summary denial order. But the state's position is the summary denial is proper in this case for the reasons, and I've already cited the reasons, and I'm almost on y'all's time now rather than mine. But the claims are conclusively rebutted by the record. A number of the subsidiary ineffectiveness claims are themselves procedurally barred. There is simply nothing upon which an ineffective assistance of counsel hearing can be conducted, and there is no need for an evidentiary hearing on ineffective assistance of counsel because the issues are all very clear.
Am my recollection correct that at the time we issued this opinion, we had before us and also issued opinions in 7 other cases? And so that when I look at this opinion in Teffeteller and it says appellants, plural, that's referring to all of those defendants, all of those appellants that were before us at that time.
From the point of syntax, yes, it is, Your Honor. But again, I believe, if my memory serves me, the posture of Teffeteller's case was not exactly the same as the posture of all of the other defendants. And again,
we dealt with them all at one time, did we not? Didn't we have them all here at a hearing? Were you here?
No, not me. They were all lumped up together on the Howard Pearl issue the last time it was up.
I'd have to go and look back at the record on it. Thank you.
Sir?
You said no. I said don't paint me with that brush.
No further questions, and I have no further comment.
Thank you, Mr. Nunley. Ms. Backus?
I think he did too.
Could I ask you the same question I asked?
Yes.
Is that what you want? You want us to review the Howard Pearl issue, the testimony and all that? And then you also want us to go back and rule on all those other claims that were originally summarily denied and see whether or not any of those require an evidentiary hearing?
That's correct. All the issues are now before the court. They should be addressed by the court because they have not been previously addressed. I, on the contrary, was present during the consolidated oral argument here. And that ruling was indeed applicable to all of the defendants.
Right. So we're referring to appellants in this decision. We're referring to all of those.
Yes, you are. And in fact, a slip opinion of the caption shows in and of itself the number of defendants who were subject to the opinion. So at the time, it was a blanket type of ruling to ensure that all of the defendants who had been represented at the hearing had a chance to bring their claims to court in a proceeding that comported with due process. Right. Mr. Teffeteller was in a different procedural posture because he had never had his claims addressed by the court before. Many of the appellants in the consolidated appeal had already been through that process with the court. Therefore, Mr. Teffeteller's original Rule 3.850 issues were still pending before this court. And part of the ambiguity in trying to figure out what Judge Foxman's reasoning was for denying some of those initial Rule 3.850 motions was that he failed to attach portions of the record to his order, which reflected what portions of the record he was relying on in which to deny the ineffective assistance of counsel claim. That is argument one in the brief that's still pending before the court. I was to ask the court to look at that carefully. With regard to the pro se motion that Mr. Teffeteller wrote, Mr. Teffeteller did write a pro se motion. He did a motion to toll time for filing notice of appeal pending resolution of outstanding motions now pending before the court. When he did that, Judge Foxman asked the state to respond to that memorandum. They did respond to his motion, however, they did not address the issues of whether or not the 3.850 issues merited an evidentiary hearing. They were more a response to Mr. Teffeteller's ability to file a pro se motion. The court's ultimate order, which I have in front of me, denies Mr. Teffteller's motion because, and in the court's words, this court does not have jurisdiction in this matter pending appeal. Therefore, his pro se motion is denied. So it's my suggestion that the state never responded to that issue as well. Procedurally, the bottom line is Mr. Teffteller's case was different than everyone else's case. He did have a hearing regarding the conflict of interest claim with Mr. Pearl, and I want to touch on that before my time is gone. His case is unique in that respect as well. Judge Foxman, in interpreting the court's order, also interpreted that he was bound to adhere to the principles set out in Herich versus State, even though the factual distinctions were very different, and procedurally he was in a very different posture than Mr. Herich. As you recall, Mr. Teffteller is the criminal defendant for which Mr. Pearl had been notified by one of his friends who was a bailiff that he had heard a rumor that Mr. Teffteller was going to escape and he was going to take Mr. Pearl as hostage. In response to that information, Mr. Pearl armed himself, and he sat at counsel table during the entire trial with a gun trained on Mr. Teffteller, unbeknownst to Mr. Teffteller, because he did not disclose this information to Mr. Teffteller. Under the prevailing case law, Collier versus Sullivan, and even applying the case law of Herich versus State, Mr. Teffteller is entitled to a new trial. First of all, because Mr. Pearl operated under a real and actual conflict of interest. He would not have been placed in the position that he was placed in unless he was a special deputy sheriff, which is what he was. The bailiffs would have not given him that information unless he was a special deputy sheriff. They were his friend. They wanted him to be aware of what may happen. The moment that Mr. Pearl put his own interests before the interests of Mr. Teffteller was the moment that a conflict of interest existed. His loyalties were divided at that moment. That's when the conflict of interest existed. And that's where the adverse interest comes into play. And that is the essence of Mr. Teffteller's conflict of interest claim with regard to Howard Pearl. I'd ask the court to remand, at least for an evidentiary hearing, on the claims that are before the court that have not been properly disposed of by the circuit court. As a whole, Mr. Teffteller is entitled to a new trial at the very minimum. Thank you.
All right, thank you very much, counsel.
Thank you.
The last case on for argument this morning is Gus Beckstrom versus the Volusia County Canvassing Board.